Federalist 83. This is part 7. I mistakenly said part 5 in 2 of the videos. I'll correct that when I post them. Part 7 will start with paragraph 26. And this is one of the other books that I've already talked about. Take a look at it. It's called Explaining America by Gary Wills. Garry Wills, Wills. It's Explaining America, the Federalist. The publisher is Doubleday and Company. I'll start with paragraph 26. Please make sure that you listen to Federalists 1 and 2 for this reading to make sense. It is true that the separation of equity from the legal jurisdiction is peculiar to the English system of jurisprudence, which is the model that has been followed in several of the states. But it is equally true that the trial by jury has been unknown in every case in which they have been united. And the separation is essential to the preservation of that institution in its pristine purity. The nature of a court of equity will readily permit the extension of its jurisdiction to matters of law, but it is not a little to be suspected that the attempt to extend the jurisdiction of the courts of law to matters of equity will not only be unproductive of the advantages which may be derived from courts of chancery on the plan upon which they are established in this state, but will tend gradually to change the nature of the courts of law and to undermine the trial by jury by introducing questions too complicated for a decision in that mode. So Hamilton defends the provisions of the Constitution, and this is the last Federalist paper that has to do with the judiciary. Here he tells all the anti-federalists who are saying, because you have not mentioned in this Constitution trial by jury in civil cases, you are trying to do away with trial by jury. And he says we have not done such a thing. He's gone through the different systems in different state governments, different judiciaries, which ones used jury for trial, in what cases. And he says it is so complicated, it's so different and varies from one state to another that it would have been hard for us to put something uniform that would apply to all the 13 states in the Constitution. That's why we left it to the national legislature to write some of the rules for where civil cases can have trial by jury and where they can't. One of the things that you have to, just like this paragraph indicates, one thing you can do is there are some documentaries that talk about British history. If you haven't had a chance to look at a book about the British history or any books, then there are several good documentaries that cover the monarchy, cover just the British history in general. I highly recommend that you watch 1 or 2 of the series if possible, just to kind of have the background of where some of the American traditions, legal and otherwise, come from. It would make you understand these papers and the system that was established in the United States. We'll go to the next paragraph. These appear to be conclusive reasons against incorporating the systems of all the states in the formation of the national judiciary, according to what may be conjectured to have been the intent of the Pennsylvania minority. So notice here it talks about Pennsylvania, and here in a little bit it'll bring up Massachusetts. It says the minority in Pennsylvania, the ones that referring to the anti-federalists that were not happy that the Constitution had been ratified in Pennsylvania earlier. And some of the people in Massachusetts that are saying do not ratify this Constitution until a Bill of Rights is added. So he brings these up, and he says this is some of the stuff that they say that I don't believe in, that I agree with. Let us now examine how far the proposition of Massachusetts is calculated to remedy the supposed defect. It is in this form: in civil actions between citizens of different states, every issue of fact arising in actions at common law may be tried by a jury, if the parties or either of them request it. Now, he gave us a quotation. Now, let's see what he says. This at best is a proposition confined to one description of causes, and the inference is fair either that the Massachusetts Convention considered that as the only class of federal causes in which the trial by jury would be proper, or that if desirous of a more extensive provision, they found it impracticable to devise one which would properly answer the end. If the first, the omission of a regulation respecting so partial an object can never be considered as a material imperfection in the system. If the last, it affords a strong corroboration of the extreme difficulty of the thing. Again, keeps on saying we could not write a provision in the Constitution that would be able to cover every case for every state. We have 13 different states with 13 different cultural, economic traditions, 13 different political traditions, different constitutions. So we have to let the national legislature come up with a design where these states actually implement some of these things. But this is not all. If we advert to the observations already made respecting the courts that subsist in the several states of the Union and the different powers exercised by them, it will appear that there are no expressions more vague and indeterminate than those which have been employed to characterize that species of causes which it is intended shall be entitled to a trial by jury. In this state, the boundaries between actions at common law and actions of equitable jurisdiction are ascertained in conformity to the rules which prevail in England upon that subject. In many of the other states, the boundaries are less precise. In some of them, every cause is to be tried in a court of common law, and upon that foundation, every action must be considered as an action at common law to be determined by a jury if the parties or either of them choose it. Hence, the same irregularity and confusion would be introduced by compliance with this proposition that I have already noticed as resulting from the regulation proposed by the Pennsylvania minority. In one state, a cause would receive its determination from a jury if the parties or either of them requested it, but in another state, a cause exactly similar to the other must be decided without the intervention of a jury, because the state judicatories varied as to common law jurisdiction. So different states have different common law traditions. Some of them assign jury trials for cases, some of them won't for the same case. So he says, if we were to write something in the Constitution that would want to apply to every state, we would irritate everybody in every state. None of them would like it. because they say that would be just too sweeping, too wide of a brush. It's obvious, therefore, that Massachusetts' proposition upon this subject cannot operate as a general relation until some uniform plan with respect to the limits of common law and equitable jurisdictions shall be adopted by different states. To devise a plan of that kind is a task arduous in itself, and which it would require much time and reflection to mature. It would be extremely difficult, if not impossible, to suggest any general regulation that would be acceptable to all the states in the Union, or that would perfectly quadrate with the several state institutions. Again, we can't write something in the Constitution that every state will accept. And here in the next part, in the next paragraph, he'll say if we had chosen one state's example, then the rest of the states would have, out of jealousy, would have said, no, why did you not choose our state's judiciary as an example, and our jury systems as an example? So next part is going to be part 8, and we'll finish reading Federalist 53. I will introduce you to 2 more books that you might benefit from if you decide to read the Federalist Papers a little bit more in depth.